This lecture is on battery. Battery is defined in the second restatement, section 13, as the intentional infliction of harmful or offensive bodily contact. The problem that people have with battery is usually with the state of mind issue. You know, when someone's been touched, it's the state of mind problems that present the problems. Let me be very clear. Let's take it in small pieces so you can see exactly how the whole state of mind thing works. First, let's begin with battery. We have someone's mind. And this mind has to do two things for battery. One, it must intend to do some act. Now, when I say the mind must intend to do some act, I'm distinguishing the case where there's reflexive action, such as blinking an eye when something is coming towards your eye, as opposed to a voluntary activity where your brain says to your muscle, do something. A person is falling, and they reach out to cushion their fall with their arm. Their brain, that's not reflexive. Your brain tells your arm to move and do that. Whereas with the eye, it really is, I'm not talking about biology, but we treat that as reflexive, whereas we don't treat the movement of the arm reflexive. That went from the brain told the arm to do something. So the first step in battery is that the brain has to instruct a muscle to do something. And reflexive actions, a person who is having a seizure, for example, that doesn't count. So we'll make a note here that the blink of an eye, that is a no. That's not what's called a volitional act. Whereas bracing a fall, extending the arm to brace or fall, that's a yes. Now, in addition to this volitional act, the next requirement is that the volitional act must be the actual and proximate cause the volitional act must be the actual and proximate cause of the harmful or offensive contact. So far what we have is that the mind must instruct a muscle. So you have a volitional act, instruct the muscle to do something, and whatever the muscle did must be the actual and proximate cause of the harmful or offensive contact. We're going to come back and talk about each of these more in just a minute, but let me complete the big picture. Next, the mind must also intend to cause either the mind must intend to cause either the harmful or offensive contact, must intend to cause that harmful or offensive contact. So we'll just draw this right here. The same harmful or offensive contact. Or apprehension of same stuff. A harmful or offensive contact. So the mind has two jobs to do here to produce battery. They have to intend the act, and they have to intend to cause the requirement for the tort. Now, if this had been assault, and it's not, but if this had been assault, we'd have the same thing in the sense that the mind must, down here, the mind must intend to cause the apprehension that's required for assault. Okay? We'll deal with that more thoroughly when we get to assault. So what we have then for battery is this requirement: the mind has to intend to do an act. That act must be the actual and proximate cause of the harmful or offensive touching. Intend to cause either the harmful or offensive touching itself or the apprehension of the harmful or offensive touching. Let's talk about these individually. First of all, the volitional act, we've already talked about that. The actual and proximate causation. Now, this is rarely a problem with intentional torts, because very rarely, because the courts stretch to find if somebody intended to do something bad, then they're not going to cut off their liability very easily. And so you don't see problems, you don't see discussions, you see hardly anything about this, because it's almost never a problem, and it won't be, it's never been tested. But nevertheless, it's in there, in that the act which the person voluntarily did must be the actual and proximate cause. And we'll make a note here, this is rarely an issue and of the harmful or offensive touching. Let's talk about this harmful offensive touching. First of all, objective standards are used here rather than subjective standards. And what I mean by that is that the harmful or offensive touching must be the touching which a reasonable person would find to be harmful or offensive. It's not subjective. Did this particular person believe it was harmful or offensive? It's not the test. Would a reasonable person find that kind of touching harmful or offensive? So objective standards are used, first of all. Secondly, anything which is in close contact with a person's body will do. Touching their clothes, touching their cane, touching their purse, that's all considered sufficient touching. So I'll just put here items in close contact with the body. With the body. Now, if a person is sitting in a car and you touch the car, that's not going to be treated as a battery on the person, because the car is not associated with the person in the same way that their purse or their cane or their hat or something might be. Thirdly, a person can give consent to some harmful or offensive, what would be harmful or offensive touching. You see that in sports, where a person says, okay, we're going to play football, I consent to a certain amount of the touching. And so, but in that case, it is the harmful or offensive touching beyond the consent that constitutes the tort. So here for the note, I'm just going to put, beyond the consent. This comes up in these sports cases. Obviously, when this comes up, there'll be some question as to exactly what did the person consent to. And that's going to be fuzzy. And one side's going to argue that the person consented to this much touching. The other side's going to say, oh no, I never consented to that much touching. So you got to deal with that. Just put the arguments in there. But it's the touching beyond the consent that constitutes the battery in that case. Fourth, the awareness issue. The person does not need to be aware of the battery at the time it happens. You've all heard the famous case of the person who kissed someone while she was asleep and then left and found out about the next day. Well, it's still a battery. And you don't have to be aware of the battery at the time that it happens. For assault, you do. For batteries, you don't. Okay, and finally, let's see, I think is that everything? I think that's everything that I wanted to call to your attention. There is one more thought, and that is those cases where the person has a known sensitivity, that I am the person who is acting, and I know that this particular person is highly sensitive to something, and I act in such a way that my conduct would not be offensive to a normal person, but I know it's offensive to this highly sensitive person. And in that case, what is the rule? And the answer is nobody really knows. The restatement has declined to openly, clearly declined to take a position on that case. Prosser doesn't take a position. And so we don't know, and if it comes up, the most you can say is that there is no authoritative position on what to do in the case where the person does that. Make an argument for the intentional tort, but also argue against it. So this is the highly sensitive person. Okay, so again, to summarize the problems we have with the harmful or offensive touching, first of all, objective standards are used. It is not a question whether this person was harmed or was offended. It's a question of would a reasonable person in that person's position have been found this to be harmful or offensive. Items touching includes items close contact with the body. When people have consented to a certain amount of contact, it's a contact beyond the consent that is the harmful or offensive. A person does not have to be aware at the time, and for hypersensitive persons where you know, it's not just that the person is hypersensitive, it's that you know they're hypersensitive. This should be listed as known hypersensitive person, and we don't know what the rule is on that. Again, the restatement has openly declined to take a position. Finally, we come back here, so we understand this pathway. The mind must intend the act that was the actual and proximate cause of the harmful or offensive touching and all this stuff here. Now let's look at this other pathway. The mind must also intend to either cause the harmful offensive touching, and again, using objective standards, the mind must intend to cause the touching or cause the apprehension of the touching. Okay. Now, there are some problems here, because when we say you must intend this, I'm going to make myself some more space here to write on the board, and then I'm going to bring this one here. I need to make space to write here. So. And this is the So the person must either intend to cause either the harmful or offensive touching or the apprehension of it. And I want to make some notes under this. Number one, that when you say someone intends to do something, that means that they want to achieve that goal. But what you need to know is that substantial certainty is a substitute for intent. So substantial certainty the person has to know with substantial certainty that if I do X, Y will happen. If the person is sitting down in a chair and they're just about to touch the chair and I pull the chair from under them at that point, I am substantially certain the person's going to fall. Okay? And that's that famous case with Garrett versus Daley from the state of Washington, 1955 case where the boy pulled a chair from under someone. But if you pull a chair from someone when they're sitting down in that manner, you are substantially certain that they're going to receive an harmful or offensive touching. Okay? And that's as good as an adequate substitute for intent. However, be careful, because if it's merely highly probable, highly likely, okay, that is not, no, okay? That is not adequate intent. You've got to go to negligence in that case, okay? Next, you need to know that insane people can do this. Insane people can commit battery. Why is that? Because the only intent you need to do the battery is the intent to move your body, which insane people can do, and intent to cause an offensive touching. And one of the leading cases, there was a nurse in a psychiatric facility, and the patient at the facility grabbed a leg of the table and hit the nurse with it. And his defense was, I'm crazy. And the court says it doesn't matter, because the only state of mind you have to have is, first of all, to be able to move your arms. You could do that. And secondly, you have to intend to cause this person bodily harm. And if hitting her with a leg of the table, you knew you were trying to hurt her. And so that's all the intent you need. So crazy people can do it. Minors can commit battery for the same reason, because the only intent you need are the ones that I just mentioned. And finally, there's the concept of transferred intent. And the transferred intent, you recall that the deal is that if I'm trying to assault someone and I end up battering them, that's okay. The intent for assault is good enough for battery. If I'm trying to batter somebody and I end up assaulting them, that's perfectly okay. The intents can be transferred. If I'm trying to assault A, but I battered B, that's okay too. If I'm trying to batter X, but I assaulted Y, that's okay too. All these transferred intents. In fact, there's a problem here with transferred intent where you could pick up some extra points on the exam. Prosser, in one of his earlier, in his original edition, said that you should be able to transfer intent among all 5 of the common law intentional torts. You know the 5 common law intentional torts: assault, battery, trespass to land, trespass to chattel, a conversion, and what did I leave out? Assault, battery, trespass to land, trespass to chattel, and conversion. All 5 of those common law intentional torts, Prosser says that you should be able to transfer intent among them. But then his second edition, he changed his mind and said, well, between assault and battery, you could be able to transfer them from tort to tort and from person to person, but I'm not so sure you should be able to do that among the other 3. And so there's a dispute now as to does the transferred intent doctrine apply to all 5 of the common law torts or not? And so what has happened so far is that first the outlines, like the bar outlines, most of them, for the major bar review courses, just list all 5 of them and say that all 5 are interchangeable. And you can take that position. The restatement, the second restatement, adopts it for assault and battery only. They don't say that you can transfer among all 5 of the torts, just among assault and battery. For the bar, tell the bar about the dispute. So the outlines are saying all 5. The restatement is saying A and B. For the bar, just discuss it. That is, I think, everything I can think of that you might want to know about the law of battery. Let's do a quick summary. For this pathway here, the mind has to intend to cause either the harmful or offensive touching, or using objective standards. The mind has to intend to cause the kind of harm that a reasonable person would find offensive, or the mind must intend to cause apprehension of that. With regard to this intent, substantial certainty will do, highly probable will not do. Insane people can have the states of mind that are required for battery. Minors can. Transferred intent doctrine is all over the place. Many of the outlines say use all 5. Prosser used to say use all 5. Prosser has resorted to just these 2. The restatement uses just these 2. for the bar exam, just discuss it. And then finally, the harmful or offensive touching. Objective standards are used again. Would a reasonable person find this touching to be harmful or offensive? Secondly, if you touch items closely associated with the person's body, that's good enough. If the person is given some consent, then it is the harmful or offensive touching beyond the consent that constitutes a battery. Person does not need to be aware of the battery at the time that it happens. And for the known sensitive people, again, we don't know what the rule is because the restatement has declined to take a position, and we don't have many cases dealing with that. And that, so that's the bottom pathway. And then finally, the top pathway here, you have to intend a volitional act, such as moving the arms as opposed to blinking the eye. And that body movement, the movement of muscle, must be the actual and proximate cause. This is never an issue, but it's you put it in there. Must be the actual and proximate cause of the harmful or offensive touching, again, using objective standards. Now, one last thing over here, let me put this on the board, that once you have established the battery, for all the reasons we've talked about, that the liability extends to unforeseeable consequences. Because this is nothing more than the thin skull plaintiff. That once you've committed the battery, then the person dies. You may be liable for the death. So that's just a thin skull plaintiff. And that, I think, is everything that you will want to know about the law of battery for exam purposes. And that is the end of this lecture.